We usually think a not guilty verdict is the end of the story, right? Case closed, everybody goes home. But what if it isn't? What if you could be acquitted, walk out of court a free person, but still be legally on the hook for the exact same act? Well, that's the head-scratching legal puzzle we're going to solve today.
So let me just put the question out there, point blank. Can someone be found not guilty in a criminal trial and yet still be forced to pay damages for that very same act? I mean, it sounds completely contradictory, doesn't it? Like a paradox. But as we're about to find out, Philippine law has a really fascinating and surprisingly clever answer.
And this isn't just a theory. This happened in a real Supreme Court case, Kane versus Roggenkamp. Let's break it down. You had the criminal case. Alastair John Kane was charged with physical violence. The verdict? Acquitted. But hold on, because that wasn't the end of it. Then came the civil case, where Patricia Roggenkamp sued for damages for the very same incident. And that left this massive question hanging in the air. Was he still liable?
To figure this out, we have to get our heads around a core legal idea. A single wrongful act can actually create two totally different types of legal trouble. It can send you down two completely separate paths to justice.
Okay, so the first path is the one we're all pretty much familiar with. It's called civil liability ex delicto, which is just a fancy legal way of saying liability from the crime. The rule is simple. If you commit a crime, you have to pay for the damages you caused. Think of them as linked. A criminal conviction usually means you have to pay up. No conviction, no payment. Simple as that.
But, and this is a huge but, there's an exception to the rule, a totally different path called an independent civil action. This is a separate lawsuit for damages that can just march forward all on its own no matter what happens in the criminal case. And this, right here, is the key to understanding this whole situation.
So where does this idea of an independent action even come from? Well, its power comes from a very specific and very important part of the law, Article 33 of the Civil Code. And you really have to pay attention to the wording here. The law says that for certain cases, like physical injuries, a civil action can be entirely separate and distinct. But here's the kicker. It says it shall proceed independently. Those words, shall proceed independently, carry so much legal weight. It's not a suggestion, it's a command.
So what does this actually look like in the real world? Well, it means you essentially have two cases running on parallel tracks that don't need to intersect. This civil lawsuit really doesn't care what happens to the criminal case. And you don't even need to tell the court you're planning to file it. It's designed to stand completely on its own 2 feet.
Okay, so this is probably the question you're asking right now. How can two cases about the same event have totally different results? Well, the answer comes down to one critical difference, the standard of proof, or, to put it simply, how much evidence you need to actually win the case.
See, in a criminal case, the prosecution has to climb a mountain. The standard is proof beyond reasonable doubt. The judge has to be morally certain that the accused is guilty. But in an independent civil case, the standard is much, much lower. It's called preponderance of evidence. All that means is that it's more likely than not that the claim is true. One is a mountain, the other is just a small hill.
Let's picture the classic scales of justice. To get a criminal conviction, the evidence has to push that scale way, way down on the side of guilt. I mean, it has to be a heavy, decisive tip. But for a civil case, the scale just needs to tip, even just a little bit. That tiny difference in weight is everything. It's why you can lose one case and still win the other.
All right, now that we've got the legal building blocks, let's go back to our main story, Kane versus Roggenkamp, and see exactly how all these rules played out for them. So here's a quick play-by-play. An incident of alleged violence happens. A criminal case is filed against Kane. He gets acquitted. But, and this is the most important part, look at why he was acquitted. The court specifically said it was due to reasonable doubt. That phrase becomes the absolute linchpin of this entire story. Because right after that, Roggenkamp filed her separate civil case using that powerful Article 33. Now, this is a legal distinction that you absolutely have to understand. The Supreme Court says not all acquittals are the same. If a court says someone is acquitted because the act never even happened, then that's it. Game over. The door to civil liability is slammed shut. But if the acquittal is based on reasonable doubt, that's different. It just means the court wasn't 100% sure. It's basically saying the act might have happened, but you didn't prove it enough for a criminal conviction. And that leaves the door to civil liability wide open. And here it is, the knockout punch straight from the Supreme Court's decision in the Kane case itself. They made it crystal clear. An acquittal based on reasonable doubt is not a barrier to filing a civil action. It only blocks a civil case if the court also says that the act itself was non-existent.
So the specific reason for Mr. Kane's acquittal changed everything. The court didn't say he was completely innocent or that the incident never occurred. It just said the prosecution's evidence wasn't strong enough to meet that super high standard of beyond a reasonable doubt. And that specific phrasing was the key that unlocked the door for the civil case to move forward, with its much lower standard of proof.
So let's just boil this all down. What are the big takeaways? First, one bad act can spark two totally separate legal fights. Second, Article 33 is a powerful tool for victims of certain offenses, giving them their own path to justice. Third, the whole game changes because of the different standards of proof. And, maybe most importantly, an acquittal based on reasonable doubt is not the same thing as a court saying you are 100% innocent.
Now, you might be thinking, hold on, does this mean a victim could get paid twice? Well, the law thought of that. There's a crucial safeguard built in. Article 2177 of the Civil Code strictly prohibits what's called double recovery. You can't get damages twice for the same injury. The goal here is to make someone whole, not to make them rich. The system does have its checks and balances.
And that leaves us with one final big question to think about. This whole legal doctrine is trying to perform a delicate balancing act. On one side, you have to protect people from being prosecuted for the same crime twice. But on the other, you want to give victims a fair shot at justice, especially when that high criminal standard isn't met. So the question for us is, does the law get that balance right? That's definitely something worth mulling over.